interesting things. So here we go. Before we get started, as I always say, love connecting with you guys. And there's various ways you can connect with us on Facebook, Twitter, Instagram, YouTube. We've got all our videos uploaded onto our YouTube channel, LinkedIn, and of course, our Telegram group. And I'll talk about that in just a minute. So on our YouTube channel, and I'm going to be recording lots of additional quick information tips on immigration today, uploading them. So look out for that. And if you subscribe to our channel, you'll get alerted every time we upload some new content. It's not just our webinars, but we're going to try to record useful tips and information for you as you go on your journey that you can utilize going forward. So please make sure to subscribe so you know the latest update that we're going to have on YouTube. Today's agenda. We're going to talk about cases that impact your immigration-based petitions, cases and memos, so you know what the law is. And as you're going through this journey, I know a lot of you have got adjustment of status applications pending, but you're also on an H1B. This is a tumultuous climate in terms of businesses and the challenges they're facing. So we wanted to give you some tips so you could embark on your journey the best way possible. We're also going to give you an update from the DOS visa bulletin predictions by the man himself, Charles Oppenheimer, and talk about the prevailing wage delay and what you can do now based on the predictions to ensure you've got a successful immigration journey. So what happens to employment or company changes after the I-140 is filed? For example, what happens if, how is a petition impacted when the employee is terminated after the submission of the I-140? Well, if it is terminated after the I-140 and a withdrawn I-140 can't serve as a bona fide employment offer, you'd have to file a new I-140 with your new employer, unless it's been it's eligible for AC-21, which means the I-140 was approved and you had an adjustment that was pending for 180 days. Then if the employer withdraws it, there's no problem. Remember that even if an employer withdraws an I-140, if you have the present intent to go back and work for that employer, they can refile as long as they file the perm within 180 days. Another tip is that once an I-140 is approved, it has to be approved, that priority date stays with you, even if you file another petition. So those are some things you could think about. What happens if a business is terminated? Well, if the I-140 has been approved for more than 180 days, it's not subject to automatic revocation based on withdrawal or termination of the business. And after it's approved, you do retain the priority date. So for purposes of H1B extensions and so forth, you can still utilize that, which is really critical. What happens if the business is terminated, the employer withdraws the I-140? You always, as I said, retain your priority date once it's approved, and unless it was revoked because of fraud or misrepresentation. So hopefully for the most part, that didn't take place. Or if the USCIS determines that there was some a material error, like, for example, the I-140 shouldn't have been approved, and the USCIS erred originally in the approval. What happens if the I-140 is withdrawn before 180 days, or the USCIS denies or revokes the I-140? Approved petition does not remain valid with respect to a new offer of employment. The USCIS revokes the approval, and the correspondent adjustment is denied if pending for under 180 days. So there are all sorts of challenges, like I said, within these financial times with the employer. Like, for example, you want to change to a new employer because your employer is having some difficulties. Well, remember that you can change to, if it's approved for, if the I-140 is approved and the adjustment has been pending for 180 days, and that's the verbiage in the regulations. The adjustment was pending. So that means the receipt date, you can argue that from the receipt date onwards, the adjustment was pending. And yes, there is a difference sometimes between the receipt date and the notice date. And I looked through to see if there was any guidance given. There wasn't. So there is an argument that you can make that pending means pending. That means it was before the USCIS. So you could use the receipt date. Changes in the petition. What happens if there's a change in the job location? Well, I would really encourage you to look at some of our Perm YouTube webinars, because one of the tips I always give is, if you know that, especially if you're with a staffing company and you know that the geographic location may change, you should always file the Perm and invoke the travel may be required. So in that situation, even if you change locations, it's okay because it was outlined as one of the requirements in the Perm. But if you did not, the I-140 and the I-140 was pending for under 180 days, the Perm is based on, remember, there's a prevailing wage, so it's based on a specific geographic area. But one way to look at it is, remember, the Perm and the I-140 is for future employment. So if you're a staffing company trying to see if you can obtain, if not now, but at least when the green card is approved, another placement in that same geographic area, seeing if, you know, your employer has other contracts, maybe not specific to you right now, but has other contracts within that geographic area, so that there is the present intent to work at that geographic area once the green card is approved. And then once the I-140 is pending, and the I-140 is approved and the adjustment's been pending for 180 days, you would be able to change employers. So that, or change even geographic location. So that's some of the things you should think about. But you have to be able to, just in case it's questioned at any point, you'd have to be able to state that you did have that present intent. That means even though, you know, your employer moved you to a new locality, new geographic region, and that's outside the MSA, right? Then that you would, you know, you had a reason that he was going to try to get that position back and that employer back, or that he had other placements for you in that same geographic area. What if I'm offered a promotion? People always say, you know, I was listed as a software architect, and now I have been promoted to manage the team. Is that going to be a problem? No. They do understand that because these, you know, it's a 10-year process, that there is going to be some promotions and so forth. And that some of the job duties that were listed in the Perm actually is still part of your position. You may not be doing it on a day-to-day, but you're supervising it from other levels. So you could argue that it is same or similar. I always like to remind people this because this is a question we get every week. AC-21 means the I-140 must be approved. The I-45 has to be pending for 180 days, and then you shift to same or similar employment. How do you prove same or similar employment? Now, one of the topics I'm going to address in our YouTube videos is the guidance that the Trump administration kind of slipped in at the end for adjudicating adjustment applications. And within that, they kind of narrowed what same and similar is. But I think we could argue that, they didn't, you can't do that through a policy memo. You have to do that through notice and comment. But so the traditional way in which the USCIS looked at same or similar is the SOC system. But that's not, it says very clearly in the regs that is not the only mechanism. That's one of the factors. The job duties, wages. Now, even if the wages aren't the same, that doesn't mean that that's going to be a reason that it would be denied. Skills, experience, education. And what we always do is we take what was stated in the perm. I'm not as hell-bent on the SOC code, but if it is, that's great. And then we try to massage those job duties into the new employer's job duties so that it shows that it's same or similar, and that the same requirements are needed for the job. And then, of course, you do have to file an I-45J. And yes, the employer has to sign it and the employee. And it's best to do that proactively rather than wait for an RFE, because that way, you kind of know that, I think hopefully soon they will eliminate the ability of interviews like they did in the past. And I think they are slowly going to head to that area. If I use AC-21 to port employers, do I need to earn the same salary stated on the I-140? Now, that is one of the factors they look at, but no. And let's say you change employers and, even though the regulations state you have to show ability to pay up to the green card, does the USCIS expect me to get information from my old employer? No. They understand that once the I-140 was approved, then, they've already determined the employer had the ability to pay at the time it was filed. They will look at normal raises, inflation, downturn in the economy. So if the question is raised, you want to have some sort of clear explanation for it. But I think COVID is a pretty darn good reason in this day and age. If I use AC-21 to port employers, does the employer need to demonstrate ability to pay? Now, remember that once the I-140 is approved, that's really when they look at ability to pay. So you really don't need to, per se, demonstrate ability to pay with the new employer. Now, they may have questions. Sometimes they raise questions in the interview, sometimes pursuant to an RFE, but that's usually not a major issue. I've seen that once in 25 years where that's come up. If I use AC-21 to leave the sponsoring employer, can I be self-employed? Absolutely, you can be self-employed. And get this, as long as it's same or similar. So next week, we're going to have our moderator be our guest speaker, and he's going to talk a little bit about franchises you can buy that within the computer industry, where you can be self-employed. So there are ways in which you can do things as long as it's same or similar. So we're going to have some tips for you on that next week, because I've received a lot of questions about people who are worried about being terminated from the current position, and all of them happen to be IT. But like I said, there are other solutions out there that, finding a placement on your own can be tough, again, in this economy. But, excuse me, but you can look to some of the franchises to address that. Okay, now the highly awaited Department of State predictions. And before I start with that, I wanted to set up a poll that I hope you all will, let me see. Now, I hope can where are participants? I'd like, can you raise your hand if this is the first webinar that you've come to listen? Let's see how many people, how many new folks do we have today? Wow, well, welcome. And the numbers keep growing. That's fantastic. Welcome to our weekly webinars. And for those of you who are joining for the first time, and I'm really thankful for all those people that keep listening every week. It's great to connect with all of you, and shortly I will be getting into our Q&A, but I'm sure everyone's interested in the Department of State predictions. Oops. And please let me know if you've gotten the poll or if you, okay. The April 2020 visa bulletin is out. And like I said, it released earlier than it has in the past few months. And this time it's the final action date chart that dictates, well, remember, it's a reminder that final action dates chart dictates visa availability. That means once you file, once your date is in the final action date, your child's age freezes. And there are, I know there's a lot of confusion about the Child Protective Act and CSPA. And so another one of the videos that I'll be recording today, I'm going to explain CSPA for the folks. So, you know, look out for that if that's a concern for you. And like I said, if you subscribe to our YouTube channel, then you'll automatically know when we upload new resources like that. So EB1 is current for India, EB2 advances 3.5 months, EB3 advances 2 months under the final action dates chart, but there's very little movement on the family-based charts. So here's the final action date, you know, India and China, EB1 is current after a long time, which is great. And you see how you have all the dates here for final action. Now, these are dates for filing. And you can see how they have progressed for that. And as you can see, the family-based charts have not moved significantly at all. So what are the predictions? So Charles Oppenheim is the Chief of Visa Control and Reporting Division of the Department of State. And so he started this once a month YouTube video that's now open to the public, streamed on YouTube, that where he talks about visa availability and his predictions and so forth. So these aren't my predictions. I would never choose to predict something like this, but these are his predictions. So overall, family-based usage remains low due to overseas processing limitations. There's rapid advancement of employment-based categories. And he predicts that EB1 is going to remain current. And India and China should see some movement in May. There's going to be some rapid advancement in both categories, EB2 and EB3. So how does he factor, how does he know what's involved in the final action dates? Well, he says he looks at it like a budget. You know, what's your salary and what are your expenses? So he knows what the annual limits are for preference categories, and his budgets the appropriate number each month and the usage rate and the expected some allocation for emergency, and gathering the unused numbers from overseas port. And they coordinate a lot with the USCIS. There's constant communication with them. So COVID still impacts overseas ports, and they still are seeing very little family-based usage. So they think they'll have the employment limit of at least 275,000 this year, which is fantastic. And for those of you who've joined now, please post your questions in Q&A instead of chat. Remember, there's a difference between final action and dates of filing. And it's the USCIS that actually tells you what is what they will be using for filings. And the key to that is the dates of filing, at least for overseas consular processing, allows the consulates to kind of preliminary get all the information going and everything moving. For the adjustment of status, it almost is like what they call a pre-adjudication. Now, they won't, if you filed under dates for filing your adjustment, they will review it. They won't finalize the approval until the final action dates are current, but it is reviewed. Has the employment-based utilization increased? He says lots of new filings in October and November and increased processing. And his prediction that the utilization rate will increase in the second quarter. What do the dates look like for the rest of the year? They are predicting that EB1 should remain current for the rest of the year. Unused preference petitions will be reallocated then to second EB2. And all the dates, EB2, EB3, should start accelerating. And the only issue is right now, the USCIS seems to have a handle on it. If they get overwhelmed, they may have to make some corrective measures. So why is EB2 moving slower than EB3? Fewer EB3 applicants who are ready to be processed immediately. So the dates are advancing more quickly to increase that demand and increase EB3 applications to be fully adjudicated. But they do predict, if you've got an EB2, that they will be rapid movement in May. So someone asked, how do you go about making those allocations from the unused visa numbers? So last year, there was 122,000 unused family numbers. Employment is at a minimum of 145,000 each year. And so they're estimating to allocate, and they think it will happen even this year. They think maybe even more than last year. So that's why he predicted they will have 275,000 employment base this year. Oops. Annual limits what is the spillover between EB2 and EB3? Well, annual limits by country are subtracted from the overall annual limits. And then you estimate what would be used for the remaining numbers that are in process. And so they're able, like I said, they're in close coordination with the USCIS, so they know what is coming down the pipeline. And they reallocate in strict priority date order to China and India, the earliest applications. So they priority date order without regard to foreign state, but he predicts that most of them would be allocated to India. So that's good news for a lot of you here. And then what are pre-adjudicated cases? The USCIS utilizes dates for filing. And as I said earlier, a lot of people wonder whether they'll even touch them if you filed under dates of filing. No, they do. They actually will review it. They won't finalize it, and you won't get approved until your final action date is current or your priority date is current. But they will review the petition. Department of Labor updates, yay! Remember, last week I had announced how the wage levels would be increased, that they had delayed it till May 2021, but there was going to be a substantial increase in wages. And I had said, okay, if you've got something pending, go ahead and file it. If you're an E3 or you're a H1B and you've got an extension within 6 months, or even if you don't have an extension, they could still file the LCA, but file the LCA prior to May 14th. Now we know there's an 18-month delay, so we don't have to worry about this, and hopefully all of you will be green card holders by November 2022. Remember, CAP registration is open, and there have been a lot of reports. There's some glitches within the system. So the American Immigration Lawyers Association has asked USCIS to delay, to extend the registration requirements, but as of an hour ago, they have not heard that they would do that. So it's the 25th, so it's coming up. So you want to make sure that if you haven't had your H1B registered, that you do that ASAP. If you have any questions about CAP registration, please email us at info@cellolaw.com. We've got an H1B registration guides for petitioners that we'll be happy to give you. You can visit our YouTube channel, and here's the link here for our H1B CAP webinar, where I go over it in greater detail. And but like I said, you want to make sure that you hit that deadline and you get your H1B registration done. Now, some immigration strategies. We talked about a lot of things today. We talked about change of employment, perhaps termination, and what are some things that you can do. One thing we know for sure is you've already got a priority date. If there's going to be any changes with your employment that may impact your adjustment of status, pending adjustment of status, or if you haven't even embarked on it yet, I would say do that immediately. This is the time. And if you're suspecting that there may be issues, make sure you tune into our webinar next week, where we're going to talk about some franchise opportunities for those who, are worried about what to do because of their employment. So I know I had updated a poll. I just want to make sure everyone can see the poll. Did you all get let me know if you've received the poll. Because
it's on the screen.
Oh, okay.
It's been on the screen, so I don't know if if you have to enable or host and panels cannot. I'm not sure if
well,
if we have to take it out and put it again, or because it's been there from the time you've been talking.
Okay.
I mean, when you first asked for one poll, raise hands.
Oh, people have said they saw the poll and they voted too. Okay, great.
Okay.
So, like I said, these are some strategies that we have. If like I told you, I like connecting with you. That's why I like doing these weekly webinars. Please join us, our chat for forum. It's on Telegram. It's Cella Chats, and we constantly upload that with tips and changes, and then we have a separate one for E3 visa holders. If you're part of our immigration forum, then please share it with your friends so we can increase the community and increase the engagement. I would really appreciate that. Like I said, there are different ways to connect: Facebook, Twitter, Instagram, YouTube, LinkedIn, and of course our Telegram group. If you haven't subscribed to our YouTube channel, like I said, I'm going to be posting a bunch of small videos on things like Child Protective Act, how to, issues in Perm, I-140 issues, the adjustment of status, how the adjudicator's guidelines in reviewing adjustment of status applications. So if you subscribe, then you know that you'll be alerted when we update it with new video content. And so if you've got any questions, email us at info@cellalaw.com. For a number of people, they'll tell you that we are very good at getting back to you, giving you resources. We do this, it's not, and I say we, that's a big we, it's me and my team. We do this because we're really trying to provide a service. So a lot of times, many of the people that we help have other attorneys because their employer doesn't want to change attorneys. But it would be great. Wouldn't you rather have the attorney's office doing your work that is actually the resource of the information that you're getting? Yeah. So without any further ado, let's go to Q&A. And like I said, join me next week where we'll talk about strategies for changing employers while your AOS is pending and other latest news. And so we now have Shaker Chella joining us. Hi, Shaker, how are you?
Hi, how are you?
Good, good. And before we get started, as always, I want to give a specific shout out to my team, Kara Wood and Matt Case, that helped put a lot of this content together. And even though you see my face on the video, it's my entire team that is working on getting this taken care of. So Shaker, we seem to have a good group today.
A lot of folks there. So welcome everybody, new and returning folks. Appreciate your active participation on Wednesdays and all other times. Just to set the stage, like we always say, put your Q&A in, put your questions in the Q&A box. And the chat is where we actually post some links or some, and if the attorney asks you a question, you can respond in the chat. So that way I get to see that immediately and I can relay to the attorney so she can, further provide her insight, on the question that you've asked. So having said that, I see there are some questions in the chat. So folks, just leave the questions there. Don't repeat them in the Q&A. I will get to them in the chronological order as per the timestamp. So thank you for your understanding. So let's go to the first one. First person, Nagesh Rao, looks like a new person. Welcome. My premium for downgrade is approved, but PD is wrong by 10 days in EB3 I-140. Should I correct it? If so, how?
Say that again.
My premium for downgrade is approved, but PD is wrong by 10 days.
Oh, yeah. Go ahead and get it corrected. Especially if you did it premium processing, you can email premium processing and let them know that they made a mistake and they will reissue a new approval notice.
All right. Next question is from an anonymous attendee. Can my wife start a consulting company while on H4?
Oh, absolutely. H4s on their EAD can do, and they're not limited by anything. They can do pretty much everything. So yes, your wife can start a consulting company on an H4.
Next person is Mani Kahan, a new person again. Welcome. What we are expecting the dates to be for EB3 India by October 2021.
Well, there's 275 that they've allocated. So they said that there's going to be rapid movement. And the month to look out for is May. He said that he meaning the Department of the chief that heads all the visa bulletin issues, said he expects rapid movement in EB3. So if I think we had stated that it moved by 2 months. So 2 months is not rapid. So you can probably see a pretty substantial jump by May.
All right. Excuse me. Next one, Akash Sagar, looks like a new person. By the way, when I recognize some names the first time, it's very relative, I know that. But if I've not recognized somebody new, then I'm sorry. But I think by and large, I'm pretty good at names. But I can make a mistake too. So Akash Sagar is saying, hello there, this is Akash Sagar. I have a question. I will appreciate if you can answer it in the webinar or at some point. I was with Company A. Company A filed my EB2 with PD July 2012. And then last October, it filed an EB2 to EB3 amendment downgrade with concurrent filing. In December, Company A was acquired by Company B. Since it has not been 180 days of filing, what needs to be done?
Right. First of all, they shouldn't have done an amendment. They should have just filed a new petition. But that's fine if they wanted to do an amendment. But if it is when a company gets acquired, it is called successor in interest. So they need to file an amended, again, an amended I-140 showing that it is a successor in interest. And a successor in interest is a company that is basically stepping into the shoes because of the acquisition of the previous employer. Now, they do have to show that they have taken on all the immigration liabilities, and they have to do that even if you're on an H with them. They would have had to do that prior to the acquisition. Otherwise, amended H's have to be filed. But if they do that before the acquisition and they place it all in the public access file, at least for the H's, that's an issue. For I-140s, even if they didn't do that at the time of acquisition, you can file an amended, and you would just need to show proof from the new CEO or the new, executive team, a letter from them stating that they have acquired all the immigration liabilities.
All right, another one, another new person, Kishore Budde. What is the basis on which biometrics appointments scheduled for EAD 485? Is it based on priority date, receipt date? Does category of petition, EB1, 2, 3, etc.? Thanks.
Good question. No, it does not matter whether your priority date is current or not. Remember, I had talked about that even if you filed under dates for filing, that they pre-adjudicated. So part of that pre-adjudication process is going through the biometrics. So it's usually based on whoever's desk your application is being adjudicated and how much of a backlog they have. That's why there's no, you'll hear, oh, my friend filed after me and they've already gotten their biometrics and I haven't got my biometrics yet. But it is all dependent on the workload of the person who's reviewing your petition or application.
Okay, the next person is Prashanto Dev. Looks like it's a new person too. Welcome. Will there be interview waiver for EB 485 applicants?
There may be. I think what's going to happen is USCIS is going to be overwhelmed. And as long as they're, what they may do, and this is what they did in the past, when they are getting ready to approve the petition, they may ask to see if it's, do you have current pay stubs if you haven't leveraged AC-21 or some proof that you are still working for that employer, and then they waive the interview. So we're hoping that they will come back to, in fact, there's no way that they would have staff to be able to undertake the interviews, and that would cause an additional backlog. So it is anticipated that they will do that.
All right, next one is from Ajay Kumar. When you say rapid movement, to what date the filing and final action dates will reach up to by September 2021?
I could not predict that. I can only say that I think he said that the rapid movement may be similar than what we've seen earlier. So it's going to be a substantial jump. I would say, maybe about 4 or 5 months by May. So we'll have to see. And unfortunately, as he stated himself, there's a lot of factors that go into that. They coordinate with USCIS, how many new applications are submitted, how many are pending. So a lot of those factors go into how that movement is and what the conditions are for consulates. There's still a lot of consulates that are not, opening at a regular interval. And so interviews for family-based cases are still getting, or not as high as they used. So, getting that information. So it's a lot of coordination between these various agencies.
All right, next one is from Ananta Pilaka. Looks like that's a new one too. Welcome. What would be the status if application filing is done? Do we get an EAD? Is there any upper age limit for 485?
Right. So for your children to be eligible, and I'm going to give you an answer and then I'm going to say, but it depends. For your children to be eligible for, to be part of your adjustment of status application, they have to be under the age of 21, or their CSPA age, their Child Protective Act age, has to be under 21. And like I said earlier, check out, I'm going to be uploading YouTube videos on the Child Protective Act because it's very complex. And I want to make sure everybody understands it. So please look out for that video. Like I said, if you subscribe to our YouTube channel, you'll get the update. Number two, you asked if whether you don't get automatic work authorization. That means merely filing the adjustment of status doesn't give you the ability to, is not your work authorized status. You get, when you file your adjustment of status, you're also filing for an I-765, which is an employment authorization document. And sometimes you file for the advanced parole too. Most people do. And so you after your biometrics, you'll be issued a card that would serve for advanced parole, which is travel, and employment authorization. And if you have an underlying non-immigrant visa, like you have an H1B, which I always recommend somebody has that as a safety net, then as long as you don't work with that EAD for someone other than your H1B employer, then you're fine. If you work for someone other than your H1B employer, it doesn't impact your adjustment. It just means you're no longer on H1B status. Now, your dependents who may be on an H4 or an L2, this doesn't apply to them because their status is not dependent on their employment. Their status is dependent on the principal non-immigrant visa holders' status. So they can work anywhere and do anything. I hope that helps.
Okay. Shri Kumar is the next person. My biometrics appointment is 9th April 2021. I have travel plans to India on May 5th, 2021. Can I expect to receive my EAD AP card by end of April? My case is at MSC.
Probably not. You may be just hitting the cusp right around that time. They're varying. But if you've had a H1B visa and you had it issued in India because you're traveling to India, and I think they've expanded it, but they expanded it from 12 months to 24 months, and I do believe that they've expanded it even greater than that, and Kara can confirm in chat. But you can do Dropbox. And one of our YouTube videos actually talks about Dropbox processing. So that would be something that you could leverage and not have to worry about your AP. Now, if you travel outside the country before your AP is issued, with the Trump administration, they would issue your EAD, but they would, deem your advanced parole to be abandoned. So you would just have to refile that when you get back.
All right. Next one is from Spandana Sapidi. New person, welcome. Hi, Lakshmi. Currently, I'm doing my PhD CPT. My 5 years visa got expired in August 2019. I'm planning to go to India for F1 renewal stamping. So how does it work? Could you please help me on this?
Yeah, Is this a STEM CPT or is it a 1-year CPT?
That's a 5-year CPT.
No, the visa. She said,
Yeah. Spandana, if you could put it in the chat, so that way I can see.
I want to know when your CPT is going to expire. And then I can tell you what you need to do.
Expired in August 2019.
No, your visa expired, but your CPT is still valid,
visa
right?
got expired, okay.
So, 2022.
2022.
Oh, perfect. So what you would do is you can, I think 2 weeks ago we covered, because a lot of times people don't want to go to their home country and process a new visa, but if it was issued in India, you could do Dropbox, because and just show proof of that. You can also go to Mexico. We had 2 weeks ago, we had a guest that talked about processing visas in Mexico. So you could go there if you like and get it processed before you go to India. Well, you should be, because I think anyone that has obtained a visa, so it's not just H's, anyone that's obtained a visa, and I think you said your visa expired last summer. So, you know, it's within the 24 months. So you should be able to, you would be eligible for Dropbox. And I think they just posted our Dropbox link on chat, so you can take a look at that. And that way, you know, you have some information, and I've got some guidance in there as well. Thank you for joining.
All right, next one is from an anonymous attendee. Hello, I'd like to know if there is an issue if you start at a new employer a day after leaving an old employer. New employer has been able to successfully port visa H1B transfer, as I have an I-140 approved. Thanks.
You said he wanted to change employers from when.
He wants to know if there's an issue if you start a new employer a day after leaving an old employer, and the new employer has been able to successfully port his visa H1B transfer, as I have an I-140 approved. So his question is, can he start a new job the day after leaving an old?
Yeah, as long as he's got a H1B approved for that. Is your question related to the H1B or your question related to your I-140?
Well, could you answer that in the chat, please? So we can get the clarification straight up. I don't know your name, so if you can just answer in the chat. Is your question relating to I-140 or H1B? Because he says the new company did the H1B transfer successfully, as he has a I-140 approved.
Oh, okay. How many of you have already filed an adjustment of status? Can you raise your hand if you've already filed an adjustment of status? Let's see. Wow. Okay, great. We've got about 31 people that have filed the adjustment of status. How many of you have not started your green card application at all? Raise your hand if you haven't even started your green card application. So for those people, those 14, you should get started. How many of you have you can put your hands down now. The next is, how many of you have an approved I-140, but you haven't filed your adjustment yet because you've got, you know, your date's not current? Interesting. Very good. It's always good to know where all of you stand, so that I can make sure that the content that we create helps you. Sorry, Shaker, I interrupted your.
Okay. That person did not answer, so maybe you can send an email to info@shalawlaw.com explaining your case in more detail, and be glad to send you a response. All right. It's in the chronological order. I'm going to the chat where the question was originally posted. And I see some people are still posting questions in the chat. I would request you to please post in the Q&A box. So the first question from the chat is from Tyagarajan. Do you believe PD October 2013 has a chance to become current by September 2022 in EB2, EB3? Do you believe PD October 2013 has a chance to become current by September 2022 in EB2, EB3?
That would be almost a 2-year jump. I'm not certain it's going to be that substantial of a jump by October of this year, unless, you know, there are other things that are taking place, but we'd have to wait and see. It would be that would be a pretty substantial jump, because remember, usually it's 145,000 that are allocated every year to employment-based. Now we have almost, we have more than double that amount. So in an average year at 145,000, you know, you have some movement. I would say, even if it moved by a year, I mean, you know, I don't know. I would think it would be highly unlikely, but, you know, I hope it does. Let me just put it that way.
Okay. Next question from the chat, from Prerna Talreja, new person, welcome. If someone in EB2 has downgraded to EB3 and EB2, EB3 equalize in date of being current, what gets used, EB2 or EB3? Hopefully it doesn't count twice or backlog EB3 more than necessary.
Yeah, so if you've got an adjustment, a lot of people that did downgrades, they filed a new petition. So if you filed a new petition, so you've got an approved EB2, but you downgraded, you filed your adjustment based on your downgraded EB3 new petition. When if EB2 advances to final action dates, you can do something called interfiling. Interfiling, there is no form to be used. Your attorney would just have to alert the USCIS that you have this other approval, and to use that as a mechanism to finalize your permanent residency.
Okay. Let's come back to the Q&A. Anonymous attendee, USCIS has invited folks who had H1B denial based on the now 3 rescinded policy memos to appeal their case. How to find if a case was denied as part of one of the policy memos which are now rescinded? Does the denial letter refer to any of those memos directly?
They won't refer, it depends on the subject matter. So if you look at the reason, the basis for the denial, then it may be eligible for an appeal. And if you'd like to send it to us, you can email us at info@cellolaw.com if you've had a denied case, and we can tell you whether it would be eligible for the motion to reopen.
All right. What time do we have? There are a lot of questions still.
Well, I think today, because there's so, you know, if you've got so many people joined, I want to try to answer as many as I can. So,
all right. Srinivas Vitla, returning person, welcome. This is continued to my last week question. Currently, my status is F1 STEM OPT and valid until July 2022. And visa on my passport got stamped until July 23. I applied my H1 this year for 2022 quota. If my H1 picked through lottery in next month, April 1st, 2021, then after H1B approval, I'm planning to go to India for stamping with a new H1. If any reason my H1 is not stamped or rejected, can I come back to US using my STEM OPT EAD since my EAD is valid until July 2022 and old visa got stamped until July 23? Can you please suggest?
Yeah, you can. The denial on the H1B would not adversely impact your ability to come back on an F1 as long as you can prove that you've got continued employment on your STEM CPT. You could also, if you're planning on getting a change of status, look at I think we've even posted the link in our chats. Think about going to Mexico. The adjudications out of Mexico seem to be much better for Indian nationals than the consulates in India. So we've got a resource that actually helps you go through that process. I'm not a partner with him. He's a separate company. So it has nothing to do with me. I'm not advocating it for that, but he gave us a lot of really good insights on, this consulate's good for F1 stamping and this consulate's good for E3 stamping. So I just thought that may be something that you could look into.
Okay. The next one is from another anonymous attendee. My passport submitted for renewal, and if I receive biometric appointment, then how to manage it? I have a valid USA driver license.
Right, and you'll have, I'm sure you've got proof that your passport was sent for renewal, and I know there's ways you can expedite that. So if you've got to pay an extra fee, you can expedite it. But you would just show proof that you take a copy of your passport, your old passport, have proof that you sent it in for a renewal, take your driver's license, take your other immigration documentation, and that should suffice.
Okay. Another AA, thanks for the webinar. My PD is expected to be current in final action date in a month. If there is no progress on the case, what should one do to ensure that some action is being taken and GC is being processed?
Yeah, I mean, they do. I haven't heard of any problem where when the final action dates are current that they're not processing them. So I don't think that you should worry about that. And if you feel like it, you can always call the USCIS or send them an email just to ensure that your case is being worked on. And we have a YouTube webinar that we did on how to contact USCIS that's dedicated to that. And I'm sure my folks will post the link on our how to contact the USCIS YouTube video.
Okay. Next one is Nizar. As the prediction says, the visa bulletin will move faster in coming months. Should we need to change downgrade I-140 petition filed in October 2020 to premium?
Oh, you can't, if it's a downgrade, you can't do premium because remember, they've got to ask for the perm. So you can try contacting USCIS. We've got that webinar link here with some of the ways in which we said you can contact them and see if they have it. If the USCIS can confirm, and we've done that on occasion when there was an emergency and the person, I think it was, we were concerned about their H1B getting extended based on, for full 3 years. So we contacted USCIS and they have on occasion told us, oh yeah, we've got the perm or we don't have the perm. And so if they have the perm, then you can request an upgrade.
All right. Next one is from Manish Agarwal. If we did not submit a medicals with the I-485, would you recommend interrupting to submit the medical just to expedite things?
Yeah, you can either use the receipt notice, reference that and, update your adjustment based on that, or you can wait for the RFE. Which process is better? Sometimes people worry that if you send it in, it doesn't make it to the file, even though you've got it referenced everywhere, the reference number. But you know, I don't think that there's a problem with that, but that's something you could do.
All right, next one is again from Ananta Pilaka. My H1B extension is approved under premium. My wife's H4 approval has not come since last 3 months. What would happen if the approval of H4 does not come before it expires?
Well, that's a very good question. When you file an extension, and we covered this earlier, there's a difference between an authorized status and an authorized stay. So an authorized status is like yours because you have an approval of your H1B extension. When you file an extension of stay, the mere filing of that before the expiration of your status gives you an authorized stay. So her stay is authorized, even though she doesn't have the new status. So she's not unlawfully present, even if it comes in later. And if it gets too delayed, we've already got the link for contacting the USCIS. Take a look at that and use one of those mechanisms to kind of push it along.
All right, I'm going to take the next question from the chat. And like I've said, please put your questions in the Q&A and not the chat. And, you know, the only strategy I have is to ask the question chronologically as per the timestamp. So that's what I'm doing. So I would appreciate your understanding in this regard. Next one is from Aruna Bhatt. Can I switch employer once my EB3 downgrade I-140 approved since applied date like October 29th?
Can you say that again?
Can I switch employer once my EB3 downgrade I-140 approved since applied date like October 29th? So probably applied date was October 29th. Can I switch employer once my EB3 downgrade I-140 is approved?
Yes. Remember the three things. I-140's got to be approved. I-45's got to be pending for 180 days. And it's got to be same or similar employment. And so if those three conditions are met, you can do AC-21 porting. And remember, every time you file, attach a new, like, let's say you interfile. Every time you attach a new I-140 to your I-485, you have to wait another 180 days. Now, the interfiling should be fine because you should get your green card by then, but it's something that I want everyone to be cognizant of.
All right, and back to the Q&A box. Sachin Powale, welcome, new person. Can I expect May 15, 2012 EB2 PD to be current by June 2022?
May, which
Can
day?
I expect May 15th, 2012 EB2 PD to be current by June 2022?
It is, you know, we're talking now about I think it's a jump of a year. Perhaps, you know, it moved by 3.5 months this month. I mean, it moved by 3.5 months in April. So, you know, there is a good chance that by 2022, it should be current.
All right, next one is Aruna Bhatt, new person, welcome. Can I switch employer from I-140 receipt date or approved date?
No, the I-140 has to be approved and your adjustment has to be pending for 180 days. So look for the receipt number on your adjustment, 180 days from that date. And these are all ands, these are not ors, these are ands. So that means, and you have to work for same or similar employment. That's when you can port without having to file a new green card application.
Okay. Next one is from Ashwini Dayal. Welcome, new person. I'm on an E3 visa. Can we file for a green card employment based in an EB1, international manager category, will it cause a problem with my E3 renewal in 2-year time frame?
No, it won't. And remember, now they're allowing for E3s to process premium. And if you're eligible for EB1, and I'm happy to, if you email us at info@chalalaw.com, I'm happy to share with you the requirements for EB1 filing. And let your E3 friends know there is no, even though E3s are not dual intent, E3s are permitted to file for green cards. It's in the regulations. It is some misunderstanding that people have that E3s can't file for green cards. So I even have a video on that I'd be happy to share with you. And we'd be happy to review your, whether you meet the requirements of an EB1 green card. And if you do that, remember EB1 is current right now and it's expected to be current throughout the year. So quite possibly you would be in adjustment of status and not have to worry about, extending your E3.
All right. I'm going to the chat for a question which is kind of related right now from Ravikant Nistane. New person, welcome. Which date, receipt or notice of I-145 application is counted for 180 days?
The language in the regulations is pending, and they don't clarify it. So pending to me is it is before the USCIS. And so if they've received it, I would argue that that's pending, because there are, almost a month, maybe in a month and a half difference between the receipt date and the notice date. So I think the receipt date, you could make a good faith argument. And I went and checked through to see if there was any, because we get this question a lot, and there's no clarification on this. And so as a lawyer, that's what I would argue. Pending means before, and it's been before the USCIS, so you can go on the receipt date.
Okay. And back to the Q&A box, an anonymous attendee for the now rescinded computer programming memo by USCIS for H1B. Does it apply to SOC computer programmer or similar computer program, similar computer occupations too?
Yeah, it's computer. The issue was with the computer all other, and I believe that is, it applies to all denials based on specialty occupation. That's one of the issues that came up in a federal district court. So you've got, number one, the rescinded memo, but you also have the federal district court case that talks about how they misapplied the specialty occupation. And I went through this, I think it was sometime in November. I don't know if my team can find that video, but the issue was computer all others, like the dump file in the SOC code. So because the computer all other is a dump file, they don't have a specific degree related to that SOC code. So the USCIS said, okay, we're going to deny all petitions that are filed because there's no specific degree in it. It's not a specialty occupation. And so we have argued that the SOC code has not been expanded. And in the adjudicator's field manual, it clearly states that the field or fields, even though you're looking at the DOL resources, that we have to understand that there's a changing landscape, and we can't use those what the DOL says as the end all. You have to look at the job duties, the nature of the job, and a number of other things. So I think we've got, there it is. They sent you the link for the specialty occupation, and that should clarify it for you. And it's got we talk about the court case and as a citation. So you could share that with whoever is having that specialty occupation issue.
Okay. Next one from an AA. My perm was filed in November 2020 in EB2. If I have to leave employer before I-140 is approved, will I lose my priority date? What will happen if I-140 is approved and I leave employer, assuming employer does not revoke I-140? Will the priority date be retained?
your priority date is only retained once your I-140 is approved. Okay, so once it's approved, it's retained for purposes of, you know, H-1B extensions as well as your priority date. Now, if you leave before it's approved, you know, remember, you would have, if you leave before the 180 days, and even though they don't revoke it, there's some issues we talked about earlier in our discussion. So I think that you may have issues down the road if you leave before the I-140 is approved.
Okay. Next one is from Jaspreet Singh. I-485 and I-765 is filed and is pending at this moment. My son's passport has expired and I have opportunity to split his first and last name. Currently, surname is empty. Do you suggest I should correct name after I get GC, or is it okay to change the name while renewing passport?
You can do it while renewing the passport, but I would just let the USCIS know of the change in name. So, and maybe even submit amended forms to address that. So, because you want the green card to reflect the same name that's in the passport, right? So I would do it. I would do that if you can. Not only change it, if you change it in the passport, then go ahead and make sure that it gets changed and revised for green card purposes.
Okay. Next one, Prerna Tanreja. Do we foresee EB3 India reaching January 2014 in line with AOS filing date by September 2021? I think that is what Charles may have mentioned last week. I don't know who Charles is, but
Charles Oppenheim.
Oh.
He's the Charlie, as Mac likes to call him. And this is for which category?
EB3 India.
India. And what's the priority date?
Reaching January 2014.
Yeah, I don't think he mentioned. I don't think he mentioned any specific date. I think he just talked about rapid advancement. And Kara will correct me if I'm wrong, whether it was last week or last month or this month. I think he just talked about how he could see rapid movement, but he didn't give a specific date. And Kara will post something in the chat if she has other information regarding that.
All right. The next one is from Ajay Kumar. Just trying to see if it is a question that he had already asked. My employer A filed petition in EB2 with PD at April 2012. I moved to employer B just a few months back, and employer B has not started GC process yet. How long will it take for me to get to the point of having I-140 approval by employer B once they start the process? Also, once the perm is approved, can I use that perm and apply for two I-140s? I mean, I-140 in EB2 and in EB3.
Absolutely. And that's what I suggest most people do, is file in EB2 and EB3. And we have some ways in which John is a regal eagle when it comes to perms. He's the attorney in our office that does perm processing. And there are, because the biggest delay right now is a prevailing wage. But there are a number of things you can do for the perm even without the prevailing wage ahead of time. So you're not, you can file it faster. Once it's filed, I think they're taking about 6 months to adjudicate. You know, depending on how long it takes your attorney to file the perm, I would say 6 months from that date, your perm should be certified. And get started on it now. Because this year, remember, the numbers are rapid movement. You want to make sure that you're capitalizing on that.
All right, next one is from an AA. Hi, thanks for your service for the company, and I have two questions. How long does it take to get I-485 EAD card after fingerprinting is completed? That is his first question.
How long does it take to get the after fingerprinting is completed? I don't know. I don't know if there's any specific dates. Kara can let you know on chat. I think we've seen that there's been varied differences within the time. And the reason is, like I said in my webinar last week, there's a transition period going on between the previous administration and this administration. So I don't think that there is, I don't think the processing dates, even the ones that are specified online, are really indicative of when you will get your EAD.
All right. So the second question is, currently I'm working on H4 EAD parallel. My employer has filed labor and later they will apply I-140. Do I need to switch to H1B from H4 EAD for me to keep I-140 safer after 180 days of I-140 approval, just to carry the priority date with me to be safer if the employer withdraws, if I move to a different employer?
Right, it doesn't matter whether you're on an H4 or an H1B. Once your I-140 is approved, your priority date stays with you. But if you move before then, your priority date does not vest with you. It's not yours. The I-140's got to be approved. So regardless of whether you're on an H4 EAD or an H1B, it doesn't matter. And we know that this administration, at least for the next 4 years, you're not going to have to worry about their rescinding the H4 EAD at any time. So I think you should be fine.
Okay. Next one is from Sagar Kulkarni. Hello, Lakshmi ma'am. I do not have any question, but I'm a regular attendee of your webinar. Just wanted to say thank you, and I have passed on the details of the weekly webinar to my friends.
Thank you. So what's his name?
Sagar Kulkarni.
Sagar Kulkarni. Thank you so much, Sagar, for attending our webinars every week. I really appreciate that. And then sharing it with your friends. Like I said, it really is a lot of work that we put into this. I don't, you see a lot of webinars where people will just come up and they'll just do Q&A. But we try to make sure that we, try to give you important information, try to get sources so that you can use that on your immigration journey and make that successful. And when Sagar, you do something like that, that makes me so happy. So thank you so much.
Thank you, Sagar. Appreciate that much. Next one is Ashok Jadar Moody. Would you any idea on automatic visa revalidation to travel to Canada, even visa expired for less than 30 days?
Yeah, so remember, automatic revalidation is when you travel to Canada or Mexico with your expired visa, you're able to come back in if you come back in within a certain period. But that doesn't apply if you're going to Canada or Mexico for H1B stamping, for visa stamping. Then your automatic revalidation won't help you. I would suggest, instead of going to Canada, go to Mexico. There's certain consulates in Canada that, I've had incredible arguments with them on, I think it was Calgary. They said, oh, Indian documentation we don't trust. And I said, that's racist. And that is also national origin discrimination. You can't say without any other proof that you can't trust documents from a certain country. And we finally got that issue resolved. But every once in a while you get a quirky issue in Canada. Mexico is a much better place to process. They're not as
all right,
difficult.
Next one is from Nagesh Rao. welcome. EB2, EB3 downgrade. Can we travel outside USA when AOS is pending? I know AP needs to be reapplied. No EAD, AP, or biometrics appointment yet. PD is August 2011.
Yes. Oh, sorry, go ahead.
My downgrade I-140 is approved. My fingerprints were reused and status is updated on February 3rd, 2021. When can I expect EAD, AP, or biometrics? What if biometrics are sent when we are outside the country?
Well, they would also be sent to your law firm. So your law firm could let you know and they can reschedule your biometrics. And you're absolutely right. You'll have to reapply for AP, maybe. Let's hope this administration takes out that ridiculous rule. But you can, as long as you are on an H or L, because those are dual intent. So you can intend to reside here temporarily, and you can intend to reside here permanently. If you are on any other visa rather than H and L, departing before your AP is issued, your AOS would be deemed abandoned.
Okay. Next one is from Gujan Salamuttu. New person, welcome. I really appreciate all the things you do for the immigration community. Our families and kids are very thankful for all your efforts. That's all is his comment.
Thank you, Gujan. I appreciate it.
Next one is Vishnu Aljapur. New person, welcome. I applied for I-140 downgrade and I-485 concurrently in October 2020. I-140 was receipted, but my I-485 was rejected in January 2021. Then my attorney applied again, both I-140 and I-485 in November 2020. I-140 from October got approved in premium for October filing. What happens to my I-140 application filed in November 2020?
Now, your I-140, since they reapplied the I-140, why don't they just interfile if it's not a downgrade or anything like that? Why don't they just interfile the approved I-140 with your AOS?
Okay. So that's the suggestion. If you need full clarification, just send an email to info@challalaw.
Yeah, and remember, there's no form for interfiling. It's something the attorney does. He takes the approval of your I-140 and just submits it to USCIS.
All right. Next one is from Majid Yusuf. Welcome, new person. My name is Majid Yusuf from Pakistan. Working as a cleaner, EB3, unskilled. My interview done, but from case transferred from local office, Charleston, South Carolina to Texas Service Center. My PD March 2018 and I-485 filed December 2018.
It was sent back to Texas?
Yeah.
That's weird. Was there any problem in the interview?
Majid, you want to answer that in the chat?
Or what you can do is, why don't you email us at info@challalaw.com, and that way we can ask you some questions to see why. It may have been they did that to one of our EB1s by mistake. So there may have been, like, either they may not have recognized that your priority date is current for your filing, or they made some mistake. But the only times they usually send that back is when they want the service center to re-adjudicate it. So that's why I want to ask you some questions about how the interview went. So email us, please, at info@challalaw.com so we can help you out.
All right. Next one is Shri Kumar. When we change employer based on AC-21, when should we send the 485J? My future employer's immigration team mentions that they will issue the I-485J to me when I go for the 485 interview.
No. I don't know why they would wait to that. You want to proactively tell them So if you've changed employers and you meet all the requirements of AC 21, I-140 approved, and adjustment pending for 180 days, and it's same or similar employment, ask your employer to give it to you. Now, if you proactively let them know, down the road, you may not get an interview. It may not be required. So you want to do that. You want to send them the I-45J now. And I don't understand why they don't want to do that. Doesn't make any sense to me.
Okay. Next one is Anil Manga, new person, welcome. I filed 485 as a future employer with whom I worked for 10 years. Now that I'm working for another employer and filed 485 as future employer, can you please tell me if I can use AP for travel and still be on H1 status until I get green card? Thank you.
Right. So you can travel on your AP, you can travel on your H1B visa. Either one does not impact your status. What impacts your status is if you use your EAD to work for somebody other than your H1B employer. You can use your EAD to work for your H1B employer. But if you use your EAD to work for somebody other than your H1B employer, then you're no longer in valid H1B status. I hope that helps.
Okay. Next one is from Karthik Rajashekaran, returning, welcome. I know you have answered in past the below query. Sorry for asking again, as I don't want to get my GC denied. I applied for downgrade concurrent I-485 and I-140 EB2 new and have got my I-140 approved. But change of job using AC 21 below is what my understanding. 180 days of pending 485, approved I-140. Is my understanding correct, or is it 180 days of the approved I-140?
No, you're correct. So the I-140, these are three criteria that are separate. They're not related to each other. I-140's got to be approved. Yours is approved. Congratulations. I-45 has to be pending for 180 days. Pending can be, and I have argued this before, from the receipt notice, because it's before the USCIS, so it's pending before the USCIS. 180 days, and same or similar employment.
Okay. Next one is from an AA. I have applied for EB3 downgrade for the entire family on October 30th, 2021. My PD is June 2013. Received receipt notices with dates. Have not received any fingerprint notices. Do you suggest filing premium at this point or wait till fingerprinting? My wife H4 and H4 EAD was applied in July 10th, and fingerprinting was done in September, but not yet approved, whereas my H1 was approved on November 10th.
Right. Well, the fingerprinting's done, so they may be able to utilize that for her H4 documents. They can do it for the H4s. They're not going to do it for the H1B because you haven't been fingerprinted before for the EADs. Now, I think your question was, can you premium it? Remember, if you're downgrading, if you're doing a downgrade, you filed the I-140 without the original certified perm. And your attorney must have requested, excuse me, your attorney must have requested the USCIS to obtain the certification, the perm certification from DOL. It can't get approved without that, and they can't do that in premium. So what I have suggested in the past is contact USCIS. We've got some links here that show you how to contact them. And then by contacting them, you can sometimes find out if they have the perm. And if they do, then you can file for premium, but not until then. And Shaker, I think we're coming up on our last question. I'm losing my voice.
Okay, I think there's a lot of questions still left. So at this time, so just request not to, put any more questions. And how much time do you want?
Maybe another 5 minutes. And what we're going to do is we'll download your questions, and on our Telegram group, we'll share a link to where the answers are. So if you haven't joined our Telegram group, please do, so we can do that. And what I may also do is do a YouTube video and just take the questions and answer them on YouTube. That may be the best way. So if we don't get to your question, subscribe to our YouTube channel. So, either YouTube channel or our Telegram group, and I'll make sure to answer all of them.
Okay. So we'll take, let's see, anonymous attendee, EB2 PD March 2010, filed I-485 in 2012, and been on EAD since then. Is there a chance to get GC without RFEs now? How do we trigger USCIS to get medical RFE? My EAD renewal is being filed this week. Can we send medical along with it?
Okay. If you haven't changed employers and there's no other issue when you're, I don't understand why you would think you would get an RFE, especially if you sent your medicals in now.
Right. Next one is any idea how soon you can get your EAD after biometrics appointment? My appointment was yesterday.
We're seeing a variety of dates. Some people have gotten them within 4 weeks. Some it's taken up to 8 weeks. So it just depends on a number of factors. So there's no clear, and we keep polling people, so there's no clear time frame.
Okay, I'm going to take one question from chat and then one other question, the last question from the Q&A. And if we did not answer your question, we apologize. You just send it to info@chalala.com, or as the attorney suggested, we can download and respond to the email.
Yeah, I'll do a separate YouTube and just answer all the questions. And
Sure.
What we're trying to do with our YouTube videos is index them so that you'll know where you need to go to get your question answered.
All right. So here's a question from the chat, and then there will be one more question from Q&A. Mohan Kanala. Hello, Ms. Lakshmi. Thanks for the amazing service. Do you think the recent disruptions in Texas will push back the dates?
Great question, Mohan. Thank you for listening in. No, I think it's definitely going to impact the immigration legislation, but it shouldn't impact, it has no impact on the visa bulletin dates, no.
All right. So all the others who have put questions on the chat, please, send an email or wait for the attorney to respond.
Yeah, I'm not sure if we can download the chat questions.
Yeah.
I know we can download the Q&A, which is another reason why everyone should post questions on the Q&A. But join our Telegram group and subscribe to our YouTube channel. I will be answering these questions and we'll index them so you can easily find the answer to your question if we couldn't get to it today.
Yeah, so while we are taking the last question from the Q&A, those folks who have put a question in the chat, just to be on the safe side, put it in the Q&A so we can download Q&A, questions, not the chat questions. We will explore if we can, but just to be on the safe side, so at least we have the questions. So last question for today, Rajiv Reddy. How can I link the approved I-140 with the rejected I-485 application?
Why was your 485 rejected?
Rajiv, you want to answer in the chat? So that way we bring a closure to the last question for today. I-485 application is rejected. I-140 is approved.
Yeah, so 485, was it rejected because it didn't have the 944? Was it rejected because of incorrect fees?
I'm still waiting for his response, but maybe.
If you want, you can email us at info@chalala.com. If you're trying to figure out why it was rejected, maybe you don't know, your attorney didn't tell you. And then we can tell you what you can do to make sure that they do something called a Nunc pro tunc, where they accept it as of the date it was originally filed.
Okay. I think, let me just go to the end of the chat and this Q&A, see if he's got there. No, I don't see it. So Rajiv, just send an email with the questions and with the clarification that the attorneys asked you, and glad to respond. Thank you.
Well, thank you so much, Shaker. I want to thank my team. I want to thank all of you who are still tuning in, and look out for our YouTube videos. That's what I'm going to be working on today, and hope to see you next week, where we'll have new updates, new information, and Shaker can tell us a little bit about TransWorld and the computer-related franchises you can buy.
Yeah, on that note, if I want to just say, because if I'm the one going to be speaking, it'll be helpful if you send an email again to info@chalalaw, and since I'm also one of the ones looking at the email, and then just tell me what kind of business you're looking for.
No, they've got to find something that's same or similar.
Same or similar, yeah. So if they can give some idea about what the current background is, so I can accordingly do some search and see what is available out there, or if not, I can at least have an idea, so I can have a strategy to reach my colleagues in this space. But just to for those of you who know John Milburn in our office.
Oh, that's right.
That is his birthday today, so you want to wish him happy birthday.
Happy birthday, John. Big shout out to you on YouTube, and you're everywhere now.
Yeah. So that's it.
Thank you very much, Shaker.
Thank you, Lakshman.
Bye, folks. See you next week.
Take care.
Stay safe.